Welcome to Kigali.
Thank you. It's a pleasure to be here.
Uganda has faced several challenges in the domestic investigation and prosecution of crimes. What are some of the lessons learned that will help other African countries in their efforts to seek accountability for crimes?
The important thing is to make sure that you have the capacity. We have seen an emphasis on the normative end, whereby you domesticate the Rome Statute, put in place the legal frameworks, but you really do not think about the capacity, both the human and the technical capacity. This has been one of the reasons we've had delays. For example, in terms of the human capacity, we've had judges who were previously trained to preside over these cases either being transferred or retiring, and therefore you need to have more judges trained. In terms of technical capacity, you have a registry that is also understaffed. They don't have people who can provide adequate witness protection, support victim participation. So it is very important. And also the legal framework is essential too. The temporal gap in our domestic legal framework is one of the challenges we are facing right now, and why the prosecution is bringing charges under customary international law. But also importantly, the political will. In the absence of political will, it is difficult to have these mechanisms functional. Political will see to it that the government, the executive, will allocate appropriate, sufficient resources, particularly financial resources that will enable the division execute its mandate effectively. And evidently, training for the judges, training for the prosecutors, also training for the defense counsel is essential.
And victims of international crimes are often forgotten in the process of seeking justice and accountability.
Yes.
How can the recognition of the victim's voice be improved at the domestic level and at the international level?
I think we've made remarkable strides in ensuring the voices of victims are included in international trials. Victim participation is one of the hallmarks of the ICC, and I'm happy to say it's one of the practices that the ICD has also adopted. But more needs to be done in terms of supporting the victims' legal representatives. One way of doing that is providing them with resources so that they can consult them regularly. As it stands right now, there aren't sufficient resources for legal representatives to continuously update their clients in courts, to continuously consult their clients. So it's not enough to say victims are eligible to participate. You need to support their legal representatives to do an effective voice. And then I cannot overemphasize the aspect of outreach. Outreach is absolutely essential to provide information not just to victims of the case, but also the victims of the situation, the victims of, the members of the affected community, to understand what the trial process seeks to achieve, and also to mitigate expectations in one way or another. Because, for example, in Uganda, where there hasn't been any mechanism at all and we only have trials taking place, victims have high expectations. But we know the limits of international criminal justice and what it can deliver. And unfortunately, when victims have high expectations that go unmet, that really further aggravates the situation that they're in. So outreach is absolutely essential to keep them informed about what they can achieve from the process and what they cannot achieve, and update them on the progress.
Thank you so much.